Well, tonight, suspended Chief Justice Torkonoo suffers massive legal defeat as the Supreme Court refuses her last-ditch legal attempt to stop the ongoing process to remove her. We have a minute-by-minute account of what transpired in court as lawyers for the Chief Justice fight calls for her to resign, vowing she will fight this to the very end.
Due process, rule of law, constitutionalism must prevail in Ghana. That is what we see. It is not on account of people putting pressure on the CJ to resign or do whatever that will take a decision. The most important thing is that there must be an upholding of the rule of law in Ghana. And we will continue to assert our rights. Proper thing must be done.
And now the path is clear for the Justice Woman Committee to continue investigating the petitions against her. This is Top Story brought to you by TLSL Connecting Energies. Well, tonight, Chief Justice Torkonoo has suffered a major defeat in a quest to stop the ongoing process to remove her from office. The Supreme Court, in a 5-0 unanimous decision, dismissed her application to injunct the process as meritless, paving the way for the 5-member special committee tasked with investigating the petitions against her to continue its work. The Chief Justice had contended that the entire process is unconstitutional and must be stopped, and also pushed for the removal of 2 Supreme Court judges from that committee. Member of our Legal Affairs Desk, Kwesante, was at the Supreme Court today from the very first to the last words and has joined me with update to the minute account of what exactly transpired in Kokweku. Now, even before the substantive application will be moved, the AG had issues with listing Justice Poman and Asiedu as well as other committee members as defendants in the suit.
Yes, according to Justice Sai, who appeared for the state, the Attorney General in this matter, if you look at the face of the suit, Justice Poman, Justice Adibo Asiedu, Daniel Yao Domilevo, and the other members of the 5-member committee, and Article 146 of the Constitution have been listed as defendants together with the Attorney General. The view took by Justice Sai was to the effect that, in fact, if you look at the rate that had been filed and where it had been indicated for service on the defendants, it was only the Attorney General that had been the address had been provided, and that in his view, it would have suggested that only the Attorney General was the proper party to the suit, and the other persons ought to have been removed.
Okay,
that is also that view was contrasted by Godfrey Debo Adame, who was counsel for the suspended Chief Justice Torkonoo. In his view, he said that if you look at the pleadings and if you look specifically at the relief they were seeking, some of the reliefs were actually directed at the members of the committee, in particular Justice Poman, Justice Adibo Asiedu, and the others. And so it was right for them to actually be on that action. And the Supreme Court did consider the arguments and it held, and it hold, I should say, that the view that had been taken by Justice Sai, the Deputy Attorney General, was not founded on any of the procedures of the court. And so those 5 members of the court or of the investigative body could still remain parties to this action and be listed as defendants.
So that means that Justice Gabriel Scott Poman can be there.
Yes.
Justice Samuel Kwame Adibo Asiedu can be there. Daniel Yao Domilevo can be there. Major Flora. Okay, so those are the interesting.
Yes.
Now, then came the issue of the affidavit deposed by the Chief Justice herself, alleging unfair and degrading treatment by the committee. That was thrown out in its entirety. Why?
Yes, the supplementary affidavit that was filed by the suspended Chief Justice, and in fact she deposed to those affidavits herself. The court, in a unanimous decision, also 5-0, dismissed or actually agreed with the position taken by the Attorney General and dismissed it. The Attorney General had argued that if you look at Article 146, any proceedings of the committee and Article 146 ought to be in camera. And the Chief Justice was trying to use the back door to communicate to the public of a sort, using the affidavits that she had deposed as basis to communicate some of those things. And the Attorney General was not admitting that what happened was factual or not. His view, taken by Justice Sai, was to the effect that because Article 146 mandates that all the processes under Article 146 must be held in camera, the Chief Justice could not have deposed to facts of that nature in her affidavit. That view was again contrasted by the former Attorney General Godfrey Dame, representing the Chief Justice, who did argue in open court that in his view, even if the view were to be taken that some of those depositions were actually revealing or breaching the confidential nature of Article 146 proceedings, the Chief Justice could still plead those and swear affidavits on that matter because she was in court trying to vindicate certain part of her right. In fact, initially, she took the view that body searches and other things did not constitute proceedings of the Article 146 committee. Ultimately, when the court did rule, they took the view and agreed with Justice Sai that all that had to be dismissed. In fact, let me read part of the notes that I made in court. And the affidavit contained personal claims by Chief Justice Torkonoo, including allegations of unfair and degrading treatment by the committee investigating her under Article 146. The court they find that the affidavit disclosed substantial details about the committee's proceedings that by constitutional requirement must be held in camera. The Supreme Court held that by deposing to an affidavit that revealed the inner workings of what transpired before the committee, the suspended Chief Justice had breached this constitutional safeguard. The Deputy Attorney General had earlier on referred to the Derry case and all that, and so the court ultimately agreed with him and then struck out all the supplementary affidavits in its entirety. That was the basis of the interview you did with Godfrey Dame. And in fact, that was cited in court by Justice Tanko, who said that he had heard Godfrey Dame on radio yesterday making an even more spirited argument, speaking to those affidavits prior to coming to court. And then Justice Godfrey Dame talked about how that was he had different agreement and all that, and trying to defend himself as to why he was on Joy FM yesterday and speaking to those affidavits that the Chief Justice had pleaded to.
Okay. Now, after they dealt with that, they then moved on to the substantive application for injunction itself. That also did not find favor with the court.
Yes.
What were the arguments and how did the court rule?
So on the substantive application for injunction, we know that Godfrey Dame, representing the Chief Justice, are taking the view that Justice Poaman, Justice Asiedu Adibu should be removed from the committee, for instance. It talks about how justices who serve on the committee constituted under Article 146 to investigate petitions for the removal of the Chief Justice. In this case, Justice Asiedu Adibu and Poaman have something to do with evidence that perhaps will be led at the committee. So regarding Justice Poaman, the view that was taken by Godfrey Dame was that Justice Poaman sat on a panel that adjudicated in favor of one Daniel Ofori, who is one of the petitioners currently before the Article 146 committee, and that in fact one of the petitioners had actually indicated that if he is allowed, he will call Justice Poaman as a witness to come and make those arguments in his favor at the committee, and so it will not be right for Justice Poaman to chair that committee. As regards Justice Adibu Asiedu, the argument again was that before the Chief Justice had been suspended and Vincent Ekwasefo filed his application for injunction, the Chief Justice had empaneled the court, which included Justice Asiedu Adibu, and that the view taken by Godfrey Dame was that because he was part of that panel and the president having handpicked him from the panel to be a member of the committee, that was the president overreaching and trying to tilt the balance of the court in how the decision will be made. And then Justice Tanko, Justice Bafuboni, Acting Chief Justice, did ask him that there have been several instances where judges who have been sitting on matters in the lower court, for instance at the High Court, have been handpicked by the executive president and promoted to Court of Appeal or the Supreme Court. Does that mean that that person's integrity can be questioned, for instance? And so the court did push on him to say that was not a very good point. In fact, at one point, the Acting Chief Justice asked Godfrey Dame directly, has he abandoned the point having to do with Justice Asiedu Adibu? Godfrey Dame, who was on his feet, shrugged a little bit, but said it was still part of the reliefs they were seeking from the court. The Attorney General's Department, led by Justice Sai, then came in, made the case for why he believed that the burden that needs to be discharged for an injunction application to be granted had not been met. And in fact, in the case of Vincent Okwasefua, the judgment that was published just last week, the court took its time to restate the principle that will lead to an injunction application to be granted, especially when it comes to constitutional bodies or constitutional matters where they are at play. And so ultimately, there was this back and forth. The judges, and in particular Justice Yoni Kulindi, did ask a lot of questions of Godfrey Dame and Justice Sai, and there were a lot of back and forth, and then ultimately they decided to take a break and then consider the arguments that had been made and come back with a judgment. When they came back, the Chief Justice read in open court their brief ruling. That is, by a unanimous 5-0 decision, the court had dismissed the application that was being sought by the acting chief, by the suspended Chief Justice, in this case Gertrude Torkonoo, as without any merits at all. And so the court did not find any favor in that, and then just dismissed the application by 5-0.
Quite an interesting day in court. But you spoke to lawyer for the suspended Chief Justice, Godfrey Dame, and he insists the CJ will fight this process to the very end and maintains that the current process is deeply flawed.
In fact, the words Godfrey Dame used to quote him is that the Chief Justice will continue to assert her rights when it comes to this matter. And I asked him that specific question, that you say that this process is deeply flawed and unconstitutional. Would you then advise the suspended Chief Justice to walk away from the process? Because if you don't believe that you get justice, what's the point of going the full length of it? And then his answer was that the Chief Justice will continue to assert his right. Listen to him in his own words.
Not surprising, because really follows in the theme of what we've been witnessing. But yeah, I think that we move on. There are a lot of battles that we can fight. We think that the process is flawed, no doubt. Heavily flawed, laden with all kinds of constitutional violations. And I'm quite surprised that the Supreme Court will be more or less acceding to the perpetration of such violations against the highest judicial office holder. It's not about Justice Torkonoo, as I keep saying. It's not about Justice Torkonoo at all. The issues are far-reaching. They actually impinge on matters which affect the independence of Ghana's judiciary, the security of tenure of judges and all. But if the Supreme Court, for whatever reason, does not seem to take that view, well, so be it. I think that in future, the whole nation will get to know the consequences of this.
You said there are more battles to be fought. Are there specific measures to be taken going forward?
I'm not here to disclose to you my line of action or plans. But clearly, what we can say is that this is a procedure that should be deplored. There cannot be a situation where the Chief Justice cannot face an inquiry set up under Article 146 of the Constitution to determine some inquiries against some petitions against her. And she's not had notice of the specific charges in respect of which the prima facie case has been made, the basis for such charges, and the reasons why she's supposed to go through the inquiry. This is a basic right that is available to every citizen of the country. It's not an account of her being a Chief Justice or her requesting for the grant of higher rights than as are due ordinary citizens. She's asking for basic constitutional rights. The notice of charges that she's standing trial or she's supposed to respond to, the basis for saying that it's a case for her to answer. And indeed, this is a very significant point. It's a decision that resulted in her suspension. Are you saying that she cannot know the reason why she was suspended? She cannot know the specific charges on the basis of which the president said that she should go and stay at home and for another person to assume her office? This is very strange. It's something that is very much alien to every civilized legal system. But we'll see. We'll wait the reasons and then we'll deal with it.
Finally, from in your opinion, you have said that this process is deeply flawed. There are those who are calling for the Chief Justice to simply resign and save herself all the trouble from this. As a former Attorney General, if I were to ask your opinion as a lawyer for Madam Torkonoo, what would you say to that?
Due process, rule of law, constitutionalism must prevail in Ghana. That is what we seek. It did not on account of people putting pressure on the CJ to resign or do whatever that will take any decision. The most important thing is that there must be an upholding of the rule of law in Ghana. And we will continue to assert our rights. So the proper thing must be done. As far as I'm saying, the proper thing must be done. And she is a Chief Justice. She's been in office. She's been a judicial office holder for more than 25 years or so. She's been at the bar for almost 40 years. She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on 2 matters on which she also sat be called as a witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against the Chief Justice? Clearly, it's untenable. It's only in this country that, I don't know. And the question is, on what account can she be singled out for removal from office when indeed she did not sit even alone? She sat as part of a panel.
Well, quite an interesting day in Torkonoo. And yesterday, Dami told us, Godfrey Dami told us that the CJ will be in court herself.
Yes.
And she was there. Now, what was the demeanor of the suspended Chief Justice as all these were happening?
Just around 9:30, a black Land Cruiser just parked right in front of the second entrance of the Supreme Court building. And down came the suspended Chief Justice together with her husband. They moved through the Supreme Court building downstairs. For those who know how that building works, there's a big space under it. They just walked in. And then she just made a brief stop just when we were about to climb the Supreme Court building, as though she had missed the way. She looked at it for a brief second, and then she carried on, and then she went to take a seat. When she went in there, initially, she sat behind the pews where normally the Attorney General and his team will sit. And so he sat just 2 rows behind the Deputy Attorney General, who was at the bar ready for the case to be called. And then at that time there was a case already being discussed. When that case terminated and the court was awaiting the new set of judges to come in to hear this specific matter, K.T. Hammond, who is the MP for Adansi Asokwa, who had been in court, former MP for Adansi Asokwa, former Trade Minister, walks to her. They speak briefly as though to solidarize with her, and the Chief Justice then gets up and moves to the other side where Godfrey Dame and her team of lawyers were seated. And then initially she was sandwiched by her husband to her left and then K.T. Hammond to the right. Later on, K.T. Hammond got up for another lawyer to take that seat, but K.T. Hammond was still in the pew. But generally, she carried herself with certain quiet composure throughout the proceedings. In fact, at one point, she had her leg, that is the right leg, crossed over her left knee, and that was the notes I was making. And she was leaning gently to her right, and it was engaged in some conversation with her husband and some lawyers. And then at some points, when there were questions between the bar and the bench, she just had a clenched fist. That was her left hand, and that the left was clenched, and she just put the cheeks to it, and then she just leaned back, and then she was watching as proceedings was going on. At one point, when the joke was made about how Godfrey Dame was on Joy FM yesterday, making a spirited argument of all this, that Stanko made a certain comment, and everybody laughed. The Chief Justice was not laughing. She was very focused. She was looking at the bar and the bench. And ultimately, when the judgment came down 5-0, she had lost. She was not getting to stop this process. She got up, and then together with her husband, they were holding hands. They just came out, the black Land Cruiser, back at the same place. They just sat in there and drove off.
And that's how the case went on in court today. This is Top Story. We have more for you here. Do stay with us. All right, so let me bring in now lawyer Nelson Roxon Dafiawapo. He is Majority Chief Whip and also MP for South Dai. I'm grateful to you, sir, for joining us here. If you listen to the former Attorney General, he says this is, just something that, in his word, deeply flawed. Now, people have argued that this is something the NDC is seeking to use to remove the suspended CJ at all cost.
First of all, the argument that the NDC is persecuting the CJ or pursuing the CJ in this matter is pure political propaganda. No NDC person is a petitioner in this matter, at least none that I know. The petitioners have a right to a counsel of their choosing. anybody who is a lawyer in this country who has some understanding of constitutional law and fundamental rights knows that any person who is before a court of law or a quasi-judicial body, you have the constitutional right to choose a lawyer of your choosing. So if petitioners have been given the opportunity to look for lawyers who articulate their matter, and they go for some lawyers, and because of that, somebody will want to use a certain brush to tar this matter in this manner, is totally unfortunate. So let me make the argument in the converse. The CJ also has a right to a lawyer of her choosing. Should we say that the phalanx of lawyers who are prosecuting her case, they are also MPP and as a result she's tainted? Nobody says the CJ shouldn't be a political being, but she cannot be politically partisan. So these are the issues. So I have dismissed the first point. So let's make progress.
So if you listen to, for example, I mean, the issues contained in the affidavit that was really thrown out in court today, she talks about her personal human rights being violated. I mean, this is a process as set out in the Article 146. But if you listen to her narrate the fact that even male figures are the ones searching her, really, mustn't we take a look at it because she is the CJ?
Let me tell you this. I'm a frequent user of our courts, both as an officer of the courts and as a litigant. I have about 3 cases pending as we speak before the Supreme Court. There was a time in this country, and let me be specific, the last election petition, the CJ directed that persons entering the court be searched because the security levels were heightened. Me, as a member of parliament, and as a plaintiff who had a case for that day, and also as an interested party in the election petition matter, I was searched before I entered the Supreme Court. As an officer of the court, I wasn't spared. I was searched. Do you know who searched me? A female police woman, a female police who searched me. I was searched by a woman. I was searched by a woman. I wasn't searched by a male. A male in police uniform didn't search me. It was a female in police uniform who searched me. So we can argue these matters. That is why I found the contents of the badly written contents of the CJ supplementary affidavit before the Supreme Court extremely embarrassing. One, the language was bad. There were typographical errors that the CJ couldn't take the time to correct those before deposing to it and signing off. An affidavit can come from parties, but when an affidavit is coming from somebody who is held in every jurisdiction, bar none, as the repository of all knowledge in the law, when you become the Chief Justice, the law stops with you.
Okay.
So when you depose to affidavits and grammar is bad, syntax is bad, I have a problem with it.
Okay. All right.
And it is also very embarrassing for the Supreme Court, properly constituted today, to tell a process filed by the Chief Justice that it is unmeritorious. There's nothing more embarrassing than that.
All right. Do stay with me. Let me bring in Vincent Ekwase for his MP for Utah. For Vincent, I mean, Godfrey talks about her due process and the constitutional principles that have been disregarded. Really, what specific principles of the Constitution that have been violated in this process? Vincent is on here. Vincent, I want to find out from you I mean, if you can point out to specific violations in the Constitution that the CJ side do talk about as having gone against it. Okay. Vincent, can you unmute so that we hear what you're saying? Okay, we'll try and see if we can raise Vincent back on the line. But I still have with me Roxanne Nelson Dafiamopo. He is Majority Chief Whip and also MP for South Dai. I don't know if Vincent's line is okay now. Well, no. So Roxanne, let me still come back to you.
So let me make this point. Sometime in December last year, the Honorable Afenyo Maki went before the Supreme Court and deposed to affidavit to an application asking the court to intervene in a matter that was before the Parliament of Ghana. What was it? The Honorable Afenyo Maki deposed to the fact that if the Supreme Court does not intervene, there will be a balance. There will be a shift in the balance of power in Parliament. It was contained in affidavit. The CJ presided over a panel and granted an application based on an ex parte motion. Speaker was not heard. Nobody from Parliament from our side was heard. And yet the CJ granted the application as the head of that panel. What did she do? 4 persons had breached Article 97 of the Constitution. And in the wisdom of the Speaker, they had forfeited their seats. And by that decision of the Speaker, the persons could no longer attend Parliament. And the numerical advantage was such that the minority at the time will become the majority. Very political decision. But the CJ intervened and reversed the balance of political power in Parliament.
So is this more?
The CJ is saying that the fact that her hearing was being held at the Christian Board Council constitutes a breach on her fundamental rights, and that the facility was.
Okay, well, we've lost, Dafiamopo there. But let me bring in Kwekwansa Asare. He is former director of the Ghana School of Law. You have had, some initial comment on this particular matter. Looking at where it's going, people say this is more of, no more illegal, but more of political. Do you agree with that assertion? And how do we progress on this particular matter?
It's both, my brother, it's both legal and political. It started as a controversy engrossed in law. But, as the days wear on, everything seems to be changing into controversy engrossed in politics. So it's both now.
So what must we do? How should both sides approach this so that the sanctity of the Supreme Court is maintained?
The legal team, the Chief Justice, must bring the numerous and increasing applications for injunction, for stopping, for this, for that, to an end, and allow the process, to terminate one way or the other. Or they may wish to fall on the good sense of the president to consider, lifting the suspension, or the Chief Justice herself must decide once and for all whether in her own interest it is desirable to pursue this matter to a conclusion. I wish, I should like to tell her that where we have reached now, it is the CJ says it's a no-go area for her. Okay. I can tell her that.
Okay, all right.
Because as a human being, I think that you cannot still, as head of the judiciary, and return to that same position, sit down with the executive or legislature.
Okay, all right. I'm grateful to you. Dr. Kweku Ansasari is a former director of the Ghana School of Law. This has been Top Story brought to you by Telecel, connecting energies. Up next is News Now.